Okay, Assalamualaikum warahmatullahi wabarakatuh. This is recorded lecture for the topic nuisance, Law of Thoughts 2, Laws 1341 for my students, Section 1 and Section 6. Okay, the topic nuisance actually is meant for week 8 of our lecture. So please give your full attention. As you can see on the screen, the slides belong to Prof. Nakib, and I make some editing to it, including I incorporated some slides from Prof. Mushira. Okay, let us start. All right, so this is the introduction. As you can see on the screen, it basically explains the nature of nuisance. Okay, take note that nuisance is intentional thoughts. So, the aim or the objective of the thoughts of nuisance is that to protect the rights to the use and enjoyment of one's land from what? From unreasonable interference by whom? By neighboring land users. Most of the time, it involves two parties. They are neighbors with one another. Okay, I mean, they are staying next door or side by side, okay? And then, as far as the law of thoughts is concerned, okay, it protects both rights of these neighbors. Okay, but then again, whatever the modes or the way they use their land there, whether it amounts to unreasonable interference or not. Okay, in a broader perspective, okay, actually, the law of nuisance focus more or is concerned with protection of environment. Okay, typical examples will include pollution, okay, or noxious fume, smells, interference with leisurely activities, offensive smell, I mean, it's all about smell, from premises used for keeping animals, or noise from industrial installation. So this is some of the common examples or typical examples which concern with protection of environment. And the law of nuisance is very much relevant. Okay, will be there to protect the rights of the affected parties. Okay, nuisance. Okay, when you see the word nuisance here, okay, it involves neighbors most of the time. Okay, as far as the law is concerned, okay, it's about balancing of competing rights. So it tries to strike a balance between, okay, to balancing here, the manner in which one person may wish to use his land and for his enjoyment or profit. I mean, that person, he has a right to use his land to enjoy or even to make profit. But must be balanced, okay? The right here must be balanced with the interest of his neighbor. So again, it's like a clash or balancing of competing interests here. Okay, let's go straight to the types of nuisance. The big types here, or the main type, will consist of two. Okay, as you can see on the screen, is either public nuisance or private nuisance. Okay, what is meant by public nuisance here? Public nuisance, it means an act that causes interference to the enjoyment of property. Okay, interference, the keyword, enjoyment of property, and the most important part, which is shared by the public, or it relates to public rights here. So the word public is there. Okay, as compared to private nuisance here, okay, it is also unlawful interference, but with what? With individuals' use or enjoyment of land, or some right over or in connection with it. So the highlight or the focus here is individual use, okay, or to enjoy, or the rights of individual over his land. There is also third category of nuisance here, which is known as statutory nuisance. But actually, if you look deeper, it might fall under public nuisance. Okay, for the statutory nuisance, which is based on statute. Especially the main one is EQA, Environmental, okay, Environment Quality Act 1974. But for the purpose of the lecture, so it is sufficient if you just understand, okay, and just remember that, okay, when we talk about nuisance, types of nuisance here, there are two. Okay, it's either public or private nuisance. So now we are going to discuss public nuisance. Okay, before we go to discuss public nuisance, this is the differences, okay, some of the important or key differences between these two categories of nuisance. For okay, the first one, all right, the first feature, relates to the parties involved. Who is affected? So for private nuisance, okay, the one who is affected are specific individual, or even if there are a number of individual, but it is a limited group of neighbors. Right? But for public nuisance, okay, the word public is there. So it involves usually a significant section of the public or even a class of subject. So that one is parties or who is affected or the victim here. And for the legal nature, okay, private nuisance is essentially a civil wrong, which is a tortious action. But for public nuisance, okay, it can be both. Okay, it is primarily a crime, but also can be, can take action under civil action as well. Okay, both are possible. For the basis of claim, we have discussed this now. Okay, it is about interference with individual use or enjoyment of land. So essentially, it is meant to protect land. But for public nuisance, okay, it is interference with public rights. Okay, not individual, public's right. For example, when it relates to safety or health or convenience. So again, it protects land and also other interests. All right. In terms of plaintiff potential, who can be the plaintiff? Who can sue here? Who has the local standard? So for private nuisance, only those with a proprietary interest in the land, or usually they are owners or even tenants. And then for public nuisance here, okay, who can sue? Usually the right is given to AG, the state, right? PP, even I mean, exceptionally, we are going to discuss after this. Exceptionally, individual can also sue, but again, there is condition attached to it. They must prove that they have suffered special damage. Last but not least, the last bullet there, okay, for private nuisance, plaintiff must prove damage because why? It is not actionable per se as opposed to trespass to land because that one is actionable per se. Okay, for public nuisance here, if the individual or plaintiff wants to sue, okay, he must prove special damage over and above that of public. It could be a number of people, a class of people, okay, the whole community is affected. But then, on the part of plaintiff, he suffered more, okay, above. Than whatever being suffered by other people here must prove special damage in that particular perspective. Okay, let's move forward. Okay, now we focus on discussing public nuisance here. As you can see on the screen, there are two important requirements or elements here. First, okay, must prove interference with comfort and convenience. And another important one is class of people. So both of these must be proved together one by one. So definition is the just repetition just now, okay? And the second bullet there, okay, it is stated there. It is not a requirement. No need to prove that nuisance act here, okay, must affect the entire or every single member of the society. For example, one area, people living in that area is being affected, but maybe one, two, three, four, five, not all of them. Okay, here. So no need to prove every single one of them has been affected. Okay, just a class or a group of a number of people affected. Okay, we are going to discuss one by one. The first element, what does it mean by interference with comfort and convenience? Okay, in order to explain here, okay, we are going by way of example. For example, offensive trade or keeping a disorderly house or obstruction of a public highway, okay, because public highway is meant for the public. Or holding an illegal concert in the neighborhood because why? The noise, okay, the loud noise will be a nuisance to the neighborhood, or interfering with the use of public park. Again, the word public is there, or creation of public health hazard, okay, for example, noxious smell whatsoever, or specifically, example here, a company that pollutes a river or pollutes a lake or a pond, okay, on any other body of water. So making its water unsafe for humans and animals because why? Water here is meant for the public to use. So for the first element, we just go by way of example. Okay, we go straight to the second element. What is meant by class of people here? So again, it's not that, it's not a must or that the law doesn't require or impose that you have to prove every members have been affected here. So what can be proved here? What is need to be proved? It is sufficient, okay? The law requires that only a cross section of them, okay? Just a group of them, okay? are inconvenienced or even affected here. But then again, in terms of number, how many? Okay, if you were to ask how many, how specific number? 1, 2, 3, 4. Okay. I mean, there's no specific answer for this. So Lord Denning, in case of AG and PYA queries in 1957, this is common law. He said that, I mean, he made a remark or judgment here. The question is more one of the effect. I mean, we look at the effect upon the community compared to or then one of the numbers involved. I mean, it's not about the numbers here. It depends on the effect, okay, how extensive the effect is here. So what constitutes a class or part of society is a question of facts. I mean, it might vary from one case to another, which needs to be determined on case-by-case basis. All right. Still on public nuisance, okay, this is the feature of public nuisance here. It is both a crime and or tort here. So, I mean, what is meant by it is a crime here? I mean, you can find this offense under penal code. For example, we have few sections involved. Example, section 268, subsection 1. It define what amounts to public nuisance as an offense under penal code here. You can see there, okay, clearly, this is, I just reproduce everything. So a person is guilty, I mean, you have the word guilty because this is a criminal offense. A person is guilty of a public nuisance who does any act or is guilty of an illegal omission, okay, annoyance to the public or to the people in general who dwell or occupy, okay, and which must necessarily cause injury, obstruction, danger, or annoyance to the person who may have obligation to use any public right. So you have, the words public is there, okay, to be emphasized. Okay, on top of section 268 just now, okay, we also have section 290, which talk about punishment, and also section 291, okay, repeaters, okay, or continuance of public nuisance here. But as you can see there, okay, the amount of penalty here, okay, a fine, only up to 400 ringgit, which is not that deterrent, okay. But then again, let's say the AG or the state, okay, doesn't want to sue under this section 290, they can sue under any other relevant section, even under EQA. Okay, I mean, it depends on the nature of the offense caused, okay, by the accused. Because when we talk as a crime, then we have the word PP, the public prosecutor, and accused. This is only for your knowledge, actually. Okay, as I said just now, okay, whenever a nuisance is taken or is construed as a crime, then who has the right to sue? Public prosecutor. Okay, but then can individuals sue? Actually can, all right, provided, okay, it is a person who has suffered special damage, so can claim for damages for public nuisance. I mean, it's not the case of it a private nuisance only, but only, I mean, this is meant for public nuisance. So what does it mean by the word special damage here? It includes both general damages like pain and inconvenience, and also specific expenses, okay, monetary expenses incurred by plaintiff. So this is all example of special damage suffered by the plaintiff. So he can sue under public nuisance. So, and then this is procedural, okay. If individual were to sue or asking for injunction, can they proceed without asking for consent from AG? Generally cannot, okay, but then exceptionally can here. Generally must get consent of AG. This is under section 8(1) of Government Proceedings Act 1956. Okay, but then no need to ask for consent, okay, under this exceptional situation. Okay, the first exception, prove special damage. Okay, if plaintiff can show that the nuisance which he complains is the cause of special damage to himself, then he can sue, okay, even without consent of AG. No need to ask for consent. So this is example of the case from common law. Tates and Lyle and Greater London Council 1983. Here, it involved plaintiff and defendant, very old, not really old, but the 1980s case, 1983. So defendant, they built ferry terminals on the River Thames, okay, the famous River Thames in London. Then it caused excessive silting or clogging, okay, on the riverbed. And then it caused inconvenience to river users, okay, in general. I mean, many people are affected, okay, those who are using rivers, okay, to commute, so river users. But plaintiff, okay, here, they were more affected because why? Access to their jetty was blocked. I mean, they are the jetty owner, they manage their jetty was blocked, and they had to spend a lot of money having the riverbed around dredge. I mean, to make it because it's clogged, so they have to clear the or they have to make it deep. Okay, so they have to do the dredging. So whatever expenses, okay, whatever inconvenience suffered by plaintiff here, okay, this amounted to special damage. So plaintiff can sue without asking, I mean, without asking for consent from AG. And similar to this case, okay, also involving a river or canal here, okay, Rose and Mouse, this one very old. This is 19th century, 1815. Here, defendant wrongfully obstructed a public navigable creek or public canal, okay, by mooring their boat across it. I mean, the boat cross across, okay, the canal here. So this prevented plaintiff from using the waterway. So because of this obstruction, okay, plaintiff was forced to unload goods and transport them overland. I mean, need to unload, okay, whatever goods here, and then they have to send or deliver overland via land, not by canal here. So plaintiff incurred significant extra expense and effort, although inconvenience here. So the court held that yes, obstruction here, okay, of the canal, okay, by the boat was a public nuisance. But for plaintiff, he suffered, okay, special damage, which is financial loss and extra expense. So this is distinguishable. You can distinguish, okay, we can differentiate from the inconvenience faced by the general public. So I mean, he can ask for the claim. I mean, he can get the compensation from the defendant. Okay, for Malaysian case, this is one of the leading case, okay, for public nuisance, because many cases actually are based on private nuisance rather than public nuisance. So this example of the public nuisance case in Malaysia, Pacific Engineering and Haji Ahmad Rice Mill. It involved, okay, as you can see on the picture, paddy husk. Okay, I think the when you take rice, okay, from paddy, then that's the outer layer, outer part, okay, of paddy, okay, rice. So paddy husk from defendant's factory, okay, it fly over plaintiff premises. Because why? Defendant, they burn, okay, the activity of burning the paddy husk here. Paddy husk. Okay, so plaintiff's workers had, I mean, there are special damage involved here. Okay, first, plaintiff's worker, they had to cover their mouth and noses to prevent themselves from inhaling the dust, because the dust is everywhere. So they have to cover their mouth and noses, very inconvenient. And they had to shut the door, okay, when the wind blew in their direction. And it also affected their machine. Okay, their heavy construction machines become dusty very quickly, and also their oil, okay, lubricant becomes dirty due to the dust from the paddy's house. Now plaintiff brought in an action for an injunction against defendant. All right, and the court held that, okay, the court make it clear, yes, in public nuisance, someone may institute proceedings even without obtaining prior consent from the AG, provided, okay, he proved that he has suffered special damage. So for this case, yes, okay, plaintiff had proved that they suffered personal discomfort and damage to property, damage to their heavy machine, okay, damage to their oil. And injunction against defendant burning rice husk in the compound of their premises was granted. I mean, they cannot do open burning anymore. Okay, the court allowed the injunction. All right, and this is the quotation, part of the judgment here. Okay, the court held that on the evidence before the judge, okay, it is abundantly clear that by accumulating rice husks in a large dumps and burning them on their premises, okay, the defendants created a public nuisance. So it's very much clear. So the court actually emphasized this part. Okay, and then actually before the case went to the court, okay, there was some other method, okay, attempts actually by relevant parties here. So notices were issued against them twice to abate the nuisance, or even several letters were written to them, okay, about such nuisance by the administrator, Petaling Jaya Authority, but actually they just ignore. So they keep on burning activities, okay, they keep on doing their burning activities. So that's why the court allowed the injunction. Okay, let's move to the second exception. Okay, if individual, I mean, they don't take action, so who actually can better take action? So actually, it goes to local authorities. So local authorities can seek an injunction in their own name to restrain a public nuisance within their own area. And then, I mean, it is actually statutory exception allowed by the law under Section 80 of Local Government Act 1976. So that's the provision you can read on your own. Okay. And this is the case law. I mean, this is another leading case involving local authority. MPPP, Majlis Perbandaran Pulau Pinang or Penang, uh, Penang Local Council or City Council here. Okay, and Boy Siu Tan. This is 1979. Very important because why? Judgment by federal court. So here, plaintiff, they are, I mean, MPPP, they are local authority. So they brought an action for injunction to do what? To restrain defendants okay, from using their premises as a restaurant without having obtained license from plaintiff and for damages for public nuisance. So basically, they asked the court for injunction and compensation. At the High Court, okay, the court didn't actually refer to I mean, to Local Government Act. So High Court said that or held that plaintiff could not sue, okay, defendants without consent in writing of AG. But when the case went up to federal court, okay, federal court referred to Section 80 of the Local Government Act. So the federal court said, I mean, held that yes, plaintiff had commenced its action based on this particular section, so it allows a local authority to take action in its own name. Okay, and then this is the most feasible way. I mean, this is what I mean, this is the proper way. Or maybe if individual doesn't want to take action, very hassle. So this is the way. A person or group of persons affected by the activities conducted by another on the latter's land, okay, so they have the right. They may choose to lodge a report to particular authorities. Because why? This is the common remedy, okay, widely used because there are many organizations or even government, okay, NGO or government agencies, okay, bodies, okay, whose activities are statutorily governed. So they have the rights under statute. And all, I mean, in all cases involving users here, must prove damage. Otherwise, I mean, cannot succeed. Very hard to succeed if no damage suffered by the plaintiff or by the victim. Okay, I think I stop here. There will be, I mean, I'll continue in the second part of this recorded lecture. So I stop share and I stop recording. Okay, that's all. So I'll continue in the next part.